that particular provision is attached to the orders provision. So if you end up with an order against you, they can come into your home at any time, and check and see if you're complying with it. There are also the provisions of to seize your animals and so on. And so Section 8 of the Charter protects against unreasonable search and seizure. And so we will be asking the court to look at those and ask the court to make a determination of whether or not these provisions are unreasonable pursuant to Section 8. Lastly, this one's just a little bit different than the other three. In 2009, the SPCA Act received a significant overhaul. And included in that, offense provisions were introduced for the first time. Up until then, they could really make your life hell. But other than charging you under a different piece of legislation, they couldn't actually charge you with anything under the SPCA Act. But that changed in 2009. And the penalties include, per charge, a maximum fine of $60,000 and 2 years in jail. These are significant penalties, and they even exceed the criminal code provisions prohibiting any kind of animal cruelty. So it's quite amazing, really. Now, what's to prevent the province from doing this? Well, the province can pass laws of a non-criminal nature, and they have done they have done so in many occasions, especially since the current government has come in. There are so many laws like that. But the province cannot pass criminal laws. They cannot pass them. It's in the British North American Act, going way back to 1867. The powers to pass criminal law is given to the federal government only. It's exclusive jurisdiction. Now, the province can pass these sort of what we think of as sort of regulatory type things, right? So, for example, the province can pass laws to, restrict how people sort of conduct their business and some things like that. But if it gets into something that is of a criminal nature, they can't do it. They simply cannot do it. Now, in my respectful opinion, that's exactly what they've done here in the OSPCA Act. That's exactly what they've done here. And what makes something criminal? Well, it gets into sort of some gray area, I'll have to admit. But criminal laws are essentially those types of things that are of like a moral nature, right? They're the sorts of things where we feel that they should be prohibited for moral reasons. So not like some of the provincial laws that say, if you're going to, if you're going to travel on the province's highways and it's posted at 80, you have to drive 80 or less, right? That's like, it's kind of like a number thing. Because the province, there's some safety things to consider, and basically it's just regulating an activity. But it's done, not for moral reasons, like obviously, theft, murder, these sorts of things. These are obviously the ones. Those are like the big ones, right, in the criminal code. Those are prohibited for moral reasons, and the criminal code has prohibitions against harming animals. We've had them for a very long time, and they have steep penalties as well. And so, and it's like a smell test, right? It reeks of being criminal in nature. And there is lots of case law, so it's not going to be so flowery. I can assure you that when it comes time to make these arguments, there's lots of case law where the court has struggled with these things. But I think it's clear that when the way the words of the Act are set out, it's about imposing a moral choice upon people to not harm animals. Now, you might be asking yourself, well, why? Why would the province do this? Like, if we already have a prohibition in the criminal code, like, why did they even put this into the provincial legislation, right? Well, the answer is actually fairly simple. It's easier to get a conviction. Because with criminal law, you have to prove not just that they did the thing, right? That the let's say it was animal abuse. That they didn't just they don't have to just prove that they abused the animal, but they have to also prove the state of mind that the person knew what they were doing, essentially, when they did it, right? But when it gets inserted into provincial law, and this is why it's grossly unfair, you don't have to prove that mental element. So it's much easier to get a conviction. Now, why do we have these requirements to prove the mental element? Well, when we get into these sort of morality type things, it's essential to fairness, right? I'm going to give you an example. Let's say there's a woman living in a house with 100 cats, okay? Now, this particular individual may be of the absolute and sincerest belief that she is doing the best job that she can do for these cats. And in fact, she's saving these cats, because if they were anywhere else, they wouldn't be looked after properly. Now, this particular individual may have some mental health issues. Now, would she be convicted under the criminal code? No. Now, she might lose her cats, okay? But she wouldn't get basically hit over the head with a sledgehammer in the process, when what she really needs is help, right? The reason we have these requirements in the criminal code is so that people that need help, like that particular lady might, that she can get help instead of, under the situation that we have where, with it being embedded into the provincial legislation, where she is going to maybe be thrown in jail, where she may end up having a fine imposed against her, which would potentially cause her to lose her house altogether. Things that would effectively put a person who needs some help from society on the streets. And so a situation like that is a good example of where, for whatever reason, the province has decided that we're going to put the interests of the animals so far ahead of the interests of the individual. And like I said, a situation like that, she may lose her cats, okay, if that's what needs to be done in order to care for them. And I think we can probably all accept that. But should we put her on the streets too? Like, that's not fair, right? And we've never accepted that in any other context. So why we do it in this context, it makes no sense to me. So that's why we've identified this issue as well in this application. So I suspect I'm probably out of time.
We have time for a couple of questions. If we can just turn up, where's my helper? Actually, if you'd like to stand and you can ask your question.
Thank you. I was really interested in your presentation. And one of the things that you did mention is about any legislation has to satisfy, if it is, if you succeed in your argument about Section 7, then it has to satisfy Section 1.
Yes.
And Section 1 test says, is it the undue hardship on the person? Certainly that's an issue that can be fought under Section 1 too, really, because that legislation would not clearly would create undue hardship for the person concerned.
Yes. I mean, basically, the way it works is after we prove that there's been an infringement on Section 7 or Section 8 or whatever section of the legislation, the courts will always then review it under Section 1 of the Act, which is basically, even though it infringes these sections, is it still like acceptable? In other words, can it be saved by Section 1? And that's part of any process. But in our submissions, I mean, it'll be clear that these provisions are simply not necessary. That's what it really comes down to. Is it necessary to infringe these rights of people in order to achieve some sort of greater good, right? Well, the answer is simple. No, right? Why do we have a private organization administering animal law and we don't have that with any other kind of law? Clearly, there's alternatives, right? It can be simply under the umbrella of the government. That would solve the very first one on our list. When it comes to infringing people's rights to be free of unreasonable search and seizure, you just have to put in the appropriate provisions to make sure there's proper judicial oversight, for example. These sorts of checks in the system to make sure people's rights aren't being violated, and so on. So yes, you're correct. There's that part of the analysis as well that we will be addressing.
Last question to Tom.
Okay, I'll give it to Tom, yeah.
Sorry, Dave. Thanks for doing this, Kurtis. Really appreciate clearing this stuff up for people. But hasn't the province already taken the criminal code and made it theirs with the drunk drivers criminal code, the way they've enacted that? Isn't that exactly what they've done there? And this will be just another copycat they're doing here?
Well, there's no doubt, Tom, that they're going to bring up the drunk driving legislation as those decisions on the drunk driving provincial legislations in response to point number 4. But the way that those decisions went are that under the criminal code, it's a morality question, right? Under the province, they're just saying, you can't drive on our highways if you have your blood alcohol above a certain amount, right? It's like a numbers thing. Kind of like you can't drive faster than a certain speed. You can't drive with alcohol in your system above a certain amount. And that's different than prohibiting drunk driving, just for the sake of it being a bad moral decision, right? It will take a certain amount of finesse when we make those arguments. But I don't think there's any question that we can overcome it. And I'll tell you, one example that we may be putting to the court is, for example, they have standards of care, right? And prohibitions against not meeting those standards of care. And then they also have a prohibition against causing distress. Well, the standards of care provision is more alike the sort of fixing a number to the blood alcohol level, right? There's a stronger analogy there. But the prohibition against causing and permitting animals to be in distress, there's just no way else to look at it other than it's sort of reeking of this moral choice, right? And from my perspective, at least, it should be fairly obvious that's what they've tried to do with those sections. It'll be funny if, in the end, the legislation itself ends up helping us with our argument that what they've done here is tried to pass criminal.
I was just thinking more along the lines that they're stepping into federal territory when they're creating that. Like the feds should be the one making the alcohol a criminal offense.
Yeah.
And I think this province is pretty good at stepping into that. Even with the pensions now, Ms. Wynne is going to step into the pension business as well. And so I just wonder if that's just it's an incremental step to just keep moving ahead on.
Well, I'll add one more thing to that, Tom. Like bringing these challenges forward is like if we don't bring these challenges forward, you talk about these sort of incremental steps. Well, that's exactly what you're going to get. Because at the end of the day, I'm going to give you a little piece of my own personal opinion. The way I see it is, at least in most recent years, the province is passing laws that may have constitutional issues. And they're just sort of passing them and in sort of hopes that, well, maybe it'll slide, right? Maybe it'll slide. And if nobody does anything about it, and if nobody challenges it, then we can take another step, right? And it's like that incremental thing that Tom's just describing. So if we allow that to happen, like if in this particular case, they'll take another step, and that's and that's the beauty and the value in bringing these types of applications, is because, obviously if successful, you can nip these sorts of incremental steps in the bud. Because if you don't, it will just keep creeping, right? As people become complacent, and there are decisions in the courts where you can tell, it may not be said expressly, but you can tell that they're reluctant to come to certain decisions that might be the right one because they're afraid of the chaos that may result from coming to some kind of a conclusion. And by that I mean it could have such far-ranging effects with respect to so many laws that the courts are simply reluctant to what will ultimately cause such chaos. So the longer you let this go, those steps are taken, those incremental steps are taken, and the harder it is to reel it in later. Because instead of just nipping it in the bud, you're having to deal with an enormous problem instead of what is kind of an exception type of a problem. All right? Good?